giving me the opportunity to speak here. I'm going to talk about the diminished value claims in Turkish motor third-party liability insurance, and it's going to be focused on the local legal issues. But I think it will be a reference because these claims have been included in the cover of the motor third-party liability insurance by way of legal decisions. So the insurers have faced an unexpected tail of claims in diminished value and in also loss of support, which my colleague will probably speak about tomorrow. So in third-party motor liability insurance in Turkey, the court decisions, as I said, has been the main factor in determining the profitability, because these claims were unexpected by the insurers, and through some long legal battles, finally the Court of Appeals and the higher Court of Appeals decided that loss of support and diminished value were included in the cover. And the insurers faced a sudden and unexpected loss ratio. And also due to arising from a legal battle, there were also the interest, years of interest, around 10% every year. Court expenses and attorney fees arising to 20% on the main value of the claim. So diminished value is, I'm sure you all know, is the inherent loss in a property's value due to being damaged. This is a speculative value. Actually, there may be no real damage in there, because the property may be repaired beyond the former condition. It may be as good as new, but the damage is still there, because just by being in the accident, no prudent and reasonable person would pay the same price for that property. So it's totally speculative. It may be totally repaired, but it's still there. And we will talk about it in vehicles, but it may apply to other properties such as jewelry, artwork, or houses, anything. So, as I said, it's a speculative damage. It's subjective and it's based on perception, but perception becomes reality because, as I said, no reasonable and prudent person is willing to pay the same price. So the repair doesn't matter. How good the repair is, the quality of it, it doesn't matter. The damage is still there. So in Turkish law, it arises from certain articles. First of all, the road traffic law defines the liability in case of an accident. And it refers to the Turkish Code of Obligations and the articles regarding torts in the code. And the Code of Obligations state that any person who, by a negligent and unlawful behavior, causes damage to another is obliged to provide compensation. And the amount of this compensation will be determined by a judge. So when the insurers were faced by the DV claims, their first reaction was that DV is an indirect damage. So, and indirect damages are not covered under the MTPL insurance. What is an indirect damage? It arises later on due to the accident, but not just because of the accident. However, DV is a direct damage, not an indirect damage. It occurs at the moment of the accident. Just by getting involved in an accident, the vehicle loses value. It is a sudden, instantaneous damage and a direct damage. So the Court of Appeals, reviewing the cases regarding DV claims, decided that the MTPL insurer is liable for DV claims because this is a direct damage covered under the policy. Now, I will shortly speak about the insurance general conditions in Turkey, what they are and how they are structured compared to other sources of law. So general conditions are prepared and published by the General Directorate of Insurance under the Undersecretary of Treasury. And they are published for each type of insurance, like liability insurances, fire insurances, motor hull insurances. And every insurance policy issued in Turkey must refer to one of these general conditions. And by such reference, the general conditions will become the part of policy. So they become provisions in the conditions in the policy. So yeah, they are contract terms, actually. So faced with the DV claims being in cover, the solution, there was a need for a solution. And last year, on 1st of June, there has been a new general conditions published for motor third-party liability insurance. These general conditions were trying to solve these kind of problems in motor third-party liability insurance, DV claims, loss of support claims that are burdening the insurance sector. And it contains a specific article and an addendum regarding DV claims. So the definition, I'm sorry, it didn't move, I think. Yeah, okay. So the Article A5 defines the material damages as decrease in the properties of the claimant as defined in this general conditions, including the diminished value of the damaged vehicles. So for the first time with these general conditions, diminished value was officially considered in the cover. However, it goes on. In accidents arising from the liability of the insured, the diminished value, if claimed, will be determined by the experts of the insurer licensed in the relevant branch. The diminished value will be determined in accordance with the principles laid out in the addendum to these general conditions. Now, the general conditions were getting the DV claims in the cover, but the determination of the said DV damages were based on these general conditions, how it's going to be calculated. So the addendum provided a formula for this. The formula is based on a certain variables, like the number of replacements, a constant multiplier for each type of replacement, a discretionary multiplier determined by the expert, and the vehicle's market value and the vehicle's kilometers, the aging. So an example formula would be like this, a totally mathematical formula. Now, the benefit of the formula is clear for an insurer because in facing a speculative damage, the best thing to do is to model it, to be able to know beforehand how much risk you're carrying. And the formula serves this purpose. It turns an open-ended damage type into a model damage. So, Willetberg, in limiting the exposure of the insurers to DV claims in courts, not likely. Because as we have seen, general conditions, let's see this. Yes. The general conditions are contract terms. So once they are referred in a motor third-party liability policy, they become a part of that policy, that insurance agreement between the insured and the insurer. But the claimant, which we are trying to limit the damage for, is not a party to this contract, to this agreement. So whatever defenses the insurer has in the motor third-party liability insurance or the referred general condition cannot be asserted against the claimant because the claimant has a direct right of action against the insurer. The insurer in Turkey, due to the direct right of action, as in many European countries, because it arises from the directive, has a direct right of action against the insurer. So the insurer becomes a jointly liable party alongside the insurer, insured. Now, even before our new code, our new Turkish commercial code, which entered into force in 2012, the Court of Appeals accepted this direct right of action due to interpretation of law. And what this joint liability is, the liability of the insurer in motor third-party liability in Turkey is to compensate the real damages suffered by the claimant. And it has the exact same liability as the insured has towards the claimant. Now, the real damages are the loss in the property's value. However, what the formula calculates at the end may or may not be these real damages. Because the formula is based on specific mathematical variables, it may not give, as a result, the real loss of value that the specific car incurred. So, the formula will not be the solution as it is in the general conditions, because, as I said, the damages may or may not be exact damages that the claimant suffered. Furthermore, the formula is defined in a contract term between the insurer and the insured, and so not assertable against a third party. Now, the formula and the general conditions are part of a larger discussion, because Bar of Association in Ankara already filed for the annulment of these conditions due to the same reasons I explained, and they may or may not be annulled by the Supreme Court. However, most likely the local courts and the Court of Appeals will not hold the formula as assertable against third-party claimants. Even the general conditions as they are today, including the formula, say that defenses that the insurer may have arising from the insurance agreement or from the legislation regarding the insurance agreement, resulting in the non or reduced payment of the indemnity, cannot be asserted against the claimant. So the general conditions as they are today include a formula to limit the exposure to DV claims. On the other hand, it still says that such formula cannot be asserted against third parties. The general conditions have further problems with limiting other DV claims, such as for short-term rental vehicles or antique vehicles, paying half of the damages or none at all. These won't be applicable also due to the same reasons. Now, there's another risk coming for the motor insurance in Turkey. As of last year, DV claims were just an issue for motor third-party liability insurance, and nobody considered them for casco insurance. However, last year, 17th Circuit Court of Appeals started issuing new decisions considering DV loss as a part of the casco claim. So a driver can ask the insurer for the inherent loss of value in his own vehicle in case of an accident. The casco general conditions in Turkey do not refer to DV claims at all. They are not even considered as a damage in the general conditions, and many of the casco policies do not contain special provisions regarding DV claims as of now. However, due to the nature of the DV claim, as it's a direct damage, it is perfectly in the cover of the casco insurance unless it is excluded by a general condition or a special provision. So I assume that this new risk will be taken into consideration in the underwriting of the future casco policies alongside MTPL policies. Thank you very much.